Position to start our debate on the Youth Justice Bill 2024. In doing so, I'll be going through different parts and different elements of the bill, and as most people would understand, this bill itself has over 1,000 clauses, is over 1,000 pages, and to address every clause in a 30-minute period would be quite difficult with the amount of time we have. I'll give it a go. I will give it a go, though. But the report, this bill came out originally from the report that came out, the 2017 Penny Armitage and Professor James Ogloff AM, when they published the Meeting the Needs and Reducing Offending, which was a youth justice review strategy and was classed as a landmark strategy at the time in what we needed to do with youth justice. This report originally stated, the review provides an opportunity to redesign the system to create an evidence-based response to youth offending and youth crime that is reflective of the needs and attitudes of young people and the broader community. And I think that's a really important part we have to consider. It was about also what the community views, where it wasn't just in relation to the outcomes for the young people, but it's how it impacted the whole community. Since that review, and we've seen some widespread support in some of the things that have been put forward in the past, but the Allan Labor government has really done very little when it comes to youth crime here in our state. And I'll go into that in more detail when we start to see what's happening with crime in Victoria. But we do note that because of this lack of change, there's been no real change to the youth justice legislative framework. There's been 7 years of inaction. It's 7 years of a government failing to address the root causes of youth crime, of failing the youth justice system, and as I said later, the results will speak for themselves. Youth crime continues to rise, violence is getting worse, knife crime increases, and people feel less safe in their home. This isn't coming from us, this is from speaking to victims in the community. And I have to say, when it comes to the spin from this government, the date of releasing this particular bill couldn't have come any better when you were talking about Labor spin. It came the day before the crime statistics came out in Victoria, with the largest increase we'd seen for a long period of time, particularly around youth crime and youth violent crime. And it's important to note, when the government talk about the diversion in this bill, we've got to be very cautious. Diversion away from custody or a diversion away from a person could not commit a crime is two totally different things. And I think the government is putting in place where there's going to be zero outcomes and zero responsibility for a cohort of young people. And whilst this one addresses one specific area around raising the age to 12, the government is on record saying that the goal of this is to raise the age of criminalisation to 14 here in this state. They were originally going to put it in the bill. I think they've got they've jumped a bit at the shadows in that, and they've changed that. And we have some concerns about raising the age at this time up to the age of 12. There is a red flag, and much of the government could have done with the new legislation is they should have put victims first. We should be improving safety, and we should be delivering on the main goal of the report and the review, and that's to stop young people committing crime and not pretending it didn't happen. So what is the bill about? The bill creates a standalone Youth Justice Act by removing the youth justice provisions with the Children, Youth and Families Act 2005 and placing them into one simple new act. The bill is set to raise the age of criminal responsibility to 12, and it will also set out new transport powers for Victoria Police for people who are aged 10 and 11. At this stage, I would like to move on behalf of the opposition a reason amendment. And the reason amendment follows. I move that all the words after that be omitted and replaced with the words, "This House refuses to read this bill a second time until 1. A comprehensive, fully developed and fully funded program to target and divert at-risk individuals and cohorts of young people to prevent crimes occurring is agreed to by all stakeholders. 2. Community safety concerns about the current level of youth crime in Victoria are addressed. And 3. Further assessment of the consultation on binding powers to manage young people where it is deemed their behaviour poses a risk to the safety of others is completed." There are many reasons why I will move this reasoned amendment, and none more so than ensuring that we do put as a priority the community safety. It is important to note the goal of this system, and what should be that goal is every one of us in here want to make sure that our community is safe, we prevent crimes occurring, we're supporting those who need it, and this in turn will put less people in jail. And that is our ultimate goal. 10 years into the Allan Labor government holding office, the results speak for themselves. The level of inaction is borderline offensive. Point 1 in the reason amendment is perhaps the most important element of the Armitage-Ogloff review, and was a reform that should have started straight after the review was released. If this was done at the time that the review was released in 2017, not 7 years later, you may have actually seen the impact of this, some of the changes on crime at the time we're seeing now. Chapter 4, diverting children away from the justice system. This should be the goal of all crime prevention. It should be every program should be designed to work with these young people. However, they must be held accountable still, and the young people must be held accountable for the crimes and the actions of themselves. And you cannot divert all young people away from a custodial sentence. You need only look at the Labor government decision to weaken the bail laws here in our state, and we're seeing the outcomes of that today, where people continually, young people who get bail, continuously repeat with violent crimes. We have some serious questions on this bill and the failure to address specifically Chapter 4 of that review. Whereas a comprehensive strategy that we haven't seen about targeting at youth risk from this government, there is none. We know that it is a fact the Allan Labor government, instead of working to prevent crime, they're cutting funding from crime prevention here in Victoria. In the recent state budget, the Allan Labor government have cut $20 million from crime prevention at a time crime levels are reaching record levels here in our state. This cut directly impacts on delivering these programs. It's cutting money for community-based or offender supervision. It's cutting money for youth diversion programs. And this is because the government have managed to lose control of the budget, and they've got to find ways to make savings. These savings that they're talking about now in cutting funds for crime prevention, in the long term, will cost Victorians millions, if not billions of dollars. The cost to keep a young person in custody is nearly $6,000 per day. $6,000 per day. It is cheaper to send 40 kids to Scotch College here in Victoria than it is to keep one locked up for a 12-month period. If the government was smarter in this and had done this earlier, they could have had crime prevention places in model and used that money and diverted it to ensure that we didn't cut the crime prevention here in our state. And this Act, which should be a youth justice system to address the reasons for their offending and also should address the community's concern, has failed on both parts. Point 2 of my reasoned amendment is focusing on community concerns around the rise in youth crime, especially violent crime. And I'll go through some of the statistics, but also go through some of the facts that are in there at the moment. On January 13, Ashley Gordon, a young Victorian doctor, was fatally stabbed by 16-year-olds. In the article in ABC Online, Dr Gordon's sister, Natalie Gordon, said, "The family, we're still struggling to make sense of what happened. This has affected more than our family," Miss Gordon said. "This has affected his patients, his friends. It's reached out the entire community, and I don't want anyone to feel what we are feeling." In this article, the family and friends and community who knew Dr Gordon are calling for not just the bail amendment to ensure that the bail is fixed so it doesn't happen to anyone else because these offenders were on bail, but they also are saying to the government, please ditch your push for raising the age to 14. We as a parliament must be supporting these voices, these families, these communities. The Allan Labor government must explain to the Gordon family why they are still refused to fix the bail system and ensure that there's no one else left in the same position as the Gordon family who lost their loved one, Ash Gordon. On July 2, William Taylor was another victim of the youth crime crisis in Victoria. Mr Taylor was tragically killed when a stolen car crashed into him, being driven by a 17-year-old. According to The Guardian, Thursday, July 24, prosecutors asked the court for 12 weeks to prepare the brief, but the Children's Court judge asked what evidence they had to prove he was the driver of the Jeep. And the prosecutor said police seized a pair of white shoes from the boy's home when they arrested him, which she alleged was seen on the driver was wearing in the CCTV footage of the collision. She said they also seized a mobile phone, which she alleged was used to make a call near the scene. She said that one of the two girls arrested told police the 17-year-old was a driver, so we've got a witness in it. It was alleged that this vehicle, the Jeep, was stolen in an aggravated burglary just days prior. An acting speaker, he was bailed, only to breach that bail within the next 48 hours, and the Victoria Police had to use up important resources to go and find him. Again, that's a terrible message to the family who's just lost a loved one, that it didn't matter, and the judge made a decision based on the laws in place from this government to grant bail to someone like that. The youth crime statistics in our state, we've all seen, it comes from the crime data statistics. which come out every 3 months. There has been a 20% increase in criminal incidents by youth offenders, a 20% increase in the last 12 months, Acting Speaker. Aggravated burglaries increased in that time by 18.4%. 18.4%. What's worse than that, Acting Speaker? Since 2014, aggravated burglaries have increased by 146% across our state. And it's not just in one area. It's not just in one community. It's happening across the whole state. Mildura had the #1 amount of aggravated burglaries. Berwick, #2 number of aggravated burglaries. We've got aggravated burglaries through the west, the north. They're not after just specific cars, and they're getting more and more violent. It is simply not the time to change some of these laws. We should be putting in place programs and investment to ensure these young people have a genuine opportunity to not commit the crimes in the first place. On top of this, in the last 6 years, 137 people have been injured by cars stolen in aggravated burglaries. And at this rate continues to increase. It increased by 53 people in the last 12 months, an 82% increase in the number of people who have been injured by stolen cars, and most of these, or a lot of these stolen cars, are coming from the aggravated burglaries. And the concern from the Liberal and National parties is the biggest obstacle to preventing real change is the admission that there is an issue here in the state, and the government continue to do it. In July, the Deputy Premier claimed Victoria has some of the toughest bail laws in Australia. I invite the Deputy Premier to join me to explain to the families that I've mentioned in the past who have lost loved ones, or to the many other victims of violent crime, to sit down and explain to them how the bail laws protected their families. Did the bail laws live up to the expectations of the community views? And the simple answer is no. And when it comes to raising the age in the state, I've been on record talking about I would love to have no young people in jail. That is an ideal, absolute goal that I think everyone should be targeting. How awesome would it be to have no need to have a youth detention centre in our state? It's an outcome that I know I would want. Acting Speaker, I'm very confident you would want. I'm very confident everyone in this House would never want to have a youth justice centre. However, the current circumstances show we do. Young people who commit crime and knowingly do so should be held to account. They should be held to account. And there are current laws to protect those that don't have the capacity, the Dolly Incapacts. There was a case in Victoria just this year, which is highlighted in The Age on 16th of May 2024, where a statement from the Director of Public Prosecutions, after the charges were dropped, said, "It was the Director's position that there was not reasonable prospects of a conviction in this matter because the prosecution would not have been able to rebut the presumption of Dolly Incapacts." This highlights we already have the protections in place for those young people who are 10 to 14 and older if they do not have the capability to make a decision between right and wrong. These safeguards rightly operate here in this state already. They are rightly there to protect young people who are not in that position to make a decision or to understand the consequence of their decision. They're there to protect those kids that we've already seen, some of those with mental health, some of those with a limited capacity to make decisions because of their IQ, etc. as well. These protections are already there. But this bill means a person aged 10 and 11 can never be held to account, for a violent crime. They cannot be forced into a prevention program. They cannot be forced to go through the justice system. They cannot be put into a position of a diversion. They cannot be put in a place where we can use other community facilities to give them the best opportunity and the tools they need moving forward to ensure that they don't commit crime long term. So whilst I've said before my absolute goal is to have no young person in jail, we need to have a system that any person who enters or should be entering the justice system, that we can use the wraparound services and, if need be, force these young people into those wraparound services to give them the best opportunities going forward, and that is gone once this bill goes through. There are the stats are clear, and again, it's not the right time to change this. And we believe that we must have the responsibility there. And rather than just be on the negative, I want to talk about some of the positives of things that we could look at where we can make that change. And I've had the pleasure of going over to the UK in Cheshire, who are actively working with young people. They take the health services, council services, They use all the local organisations that they can that deal with young people, whether it's not-for-profit or paid services through the state, including government and including justice. And they get the highest risk young people and they put wraparound services on each person. They had 15 when I was there, 15 extreme risk kids for committing crime. Of those 15 with the services they're provided, those services then bleed out and help other people that they're associated with. Or they identify the issues in the home and they directly work with those young people at home. They don't remove the responsibility. They don't say these kids can't get forced into some of these things. They put the practices in place to ensure that these young people, these young kids, have every opportunity to get the tools they are required to succeed in life. The government has gone on record after a 30% crime rise in Victoria, and the Victorian Police Commissioner has even stated crimes committed by 10 to 13-year-olds rose by 22.5% and offences by 10 and 11-year-olds rose by 65%. The Victorian Police Commissioner does not support raising the age to 14. He does not support it. The Victoria Police do not support it. The Victoria Police Association do not support it. And I think we need to have those voices heard in this argument. We need to understand that there's already practices in place to protect young people who do commit crime. But as I've said, one of the things I think we must be very, very cautious on, we must ensure that those 10 and 11-year-olds, that we as a parliament, we as a community, don't remove the responsibility for them committing the crime. There's other ways around it where we can ensure they get the services they need. What this bill will do is remove that, and we won't be able to have that opportunity for them. The transition provisions for this do create some issues and concerns for us, and people who have read through the bill will understand. In clause 19.1, that any criminal offence committed by a 10 or 11-year-old person before the commencement date is rendered null and void. So effectively, the charges that were there will no longer be there. The police cannot lay charges even if the investigation is commenced for anyone who's 10 or 11. Court proceedings must not be started, and if they started, they must immediately cease. Anyone serving a sentence that is a custodial sentence or any other sentence must be stopped. What a risk. If we've got a young person who's 11 years old, who's gone through the justice system, not in custody, but is currently working through having support services because the court has put it in place, we're now saying to them, you don't even need to complete your services. We're now saying to them, you don't even need to complete that with the extra support, and you or your family can say, no, we're not interested anymore. That's a negative outcome from this bill. The result message is giving effectively a green light to some of these things and creating what I would call a new norm. And whilst the 10 to 11-year-olds, the concern from some will probably be less, the government's aim is to push this up to 14. And we're seeing some of the violent crimes from 12 and 13-year-olds right now, so much so that the police commissioner came out and spoke about it. There's a whole section in the bill in relation to Aboriginal children and young persons. And there's a number of sections in this bill that set up youth justice matters specific to Aboriginal children and young persons. Part 1.3, Division 3, the guiding youth justice principles and matters specific to Aboriginal children and young persons. Part 2.3, Aboriginal youth justice agencies. Part 7.1, Clause 210, additional sentencing principles for Aboriginal children. Clause 59 will allow the Secretary to delegate specific functions to an Aboriginal Youth Justice Agency to perform, although it is not clear what these powers are. SARC has noted the effect of these clauses, 59.1 and 61.1, may be to permit the Secretary to authorise the principal officer of a registered Aboriginal Youth Justice Agency to exercise a function or power of the Secretary under the Act. And whilst I actually believe we should all be seen as one under the same law, we're living in the same country with the same law, everybody should be treated equally when it comes to the eyes of the law. I think it's very, very important. In saying that, we've been supportive of drug courts, Aboriginal courts in Victoria, but if you're going to take it where you're creating an entire new youth justice system for Aboriginal children compared to non-Indigenous children, I think you're starting to go a step too far where you're putting greater risks in there. And again, as I said before, when you're talking about raising the age, particularly with the kids with Indigenous backgrounds, we know that there's too many kids, particularly from Indigenous backgrounds, who are in the justice system and particularly in custody. But we also need to know that the programs in place from 10 to 14-year-olds, if you do commit an offence, should be there to give them the best options moving forward, to give them the best tools, to enforce education, to enforce that they go to programs for improvement, to give them the opportunities to go back to the heritage backgrounds that they have, to work with their local community groups, to work with their local elders, but it can't be in a separate justice system. should be bringing these powers into the youth justice system so they've got the power in there, not separating it and creating an entirely different program for one group of, or one cohort of children compared to another. And I think it's a great risk that we have. A big concern we have was around victims of crime. And we've always said that we must put victims of crime first. And this bill simply fails. Part 12.4, the Youth Victims of Crime Register, it is proposed that the Youth Justice Victims Register and the functionality it is proposed to have in Clause 659 falls well short of the Adult Victims Register in terms of the information given, the notice periods and the ability to influence and make submissions to proceedings. The victims on the Youth Justice Register will get very limited information considering the serious impact on their life, and they will only receive notice when the young person has applied for parole or when they have been given parole, and that is different from the adult system, and we're saying that's going too far. The victims need to be treated more respectfully for that. The impact of these changes reduce the responsibility and obligations of a young person after they commit a crime, so to effectively reduce the rights of the victims to be heard. The effect of Clause 142B, 143F, I and 144GI may be that the evidence of alleged offending for the youth warning or youth caution was given or for which an early diversion outcome was finalised is inadmissible in civil proceedings. And this is a great risk. If you're taking away the ability for evidence because it's been used in a caution or diversion to be used in civil proceedings, you're taking away the rights of victims who could be victims of violent crime, extensive damage through property, and I think it's very cautious. We have to be very cautious when we go from this. And SARC again noted that the inadmissibility of evidence of a child's alleged offending in the form of warnings, cautions and early diversions outcomes in a civil proceedings against the child may actually infringe on the victim's rights under Section 24(1) of the Charter of Human Rights. So if SARC's saying that this could have an impact on the Charter of Human Rights, where a victim who seeks civil remedy from a child has the right to a fair hearing, then these clauses make it difficult or impossible for me to support, especially on behalf of victims here in this state. And the statement of compatibility for the bill does not address these matters, which SARC noted when they made their notes in it. The Allan Labor government are ignoring the rights of victims, and we cannot stand by while that happens. This government has learned nothing from the victims of serial killers held in our prisons here in the past. The Attorney-General is quick with a media release stating, "The family and friends of Natalie Russell, Debbie Freem and Elizabeth Stevens continue to suffer and grieve," and going on to say, "We've listened to the victims and their families." The Minister for Youth Justice stated in Parliament on 29th of August 2023, "We are committed to a victim support system that respects victims' rights and helps them to fully participate in the justice system." Yet now in this bill, even by the government's own SARC report, they've gone against the Human Rights Charter and they've taken away those rights from those victims. And again, it's not something we can still do, we can support. The other thing in this when we're talking about youth justice is we note that the government, who one day was saying not a youth crime crisis, not an issue here in our state, we can't see where the real problems are, went to the next day of an urgent meeting trying to call in all people in relation to youth justice to have a talk fest here in Melbourne. And they, considering the government are consistent with the message that there's no youth crime issues, we found it very interesting that they wanted to call everyone together for a talk fest in the state. One of the problems with that talk fest is no one knows actually what's happened and no one knows what the outcomes of that meeting were. There was no agenda released. The government failed to deliver any actions that focused on reducing crime from that, and it is more about removing responsibility for young people to 12 and obviously their push up to 14. As I said before, there's other things we can do. It is really important from an opposition's perspective and a government that we look at alternatives from around the world, not just here in our state. And some of the things we can do. In Japan, young people diverted from the justice system can attend a small-scale specialised schools with their bespoke needs. And in Victoria, we're very lucky to have some of these schools. David Scott School, which I've had the pleasure of visiting, is an amazing school with fantastic outcomes. And I know the member for Frankston would know the David Scott School that's down here, a brilliant school that achieves amazing goals. And we have to look at it, and I know I've worked with kids in special schools, I've worked with kids in state schools, obviously as a police officer as well. You have to sometimes judge what a positive outcome is. And when you walk into these schools, we're not going into these schools and every kid wants to go through and get their VCE and get an amazing result and go on to become a doctor. We've got kids in these schools that just want to be accepted and then get through a system in it where they can feel they've developed some skills to go and find gainful employment or go and support others who have been in a similar position, whether it's drugs or mental health. And when you have schools like David Scott who are doing an amazing job of that, then the evidence is there. We've got Sire School in Berwick, which I know is also in the Yarra Valley. These schools, these programs need more funding. They need to be able to grow. They need to be able to give opportunity for the courts to divert these kids away from the justice system. Going to Parkville College in at Cherry Creek is not a positive outcome. Getting them into a school in the community where they can gain skillful employment, they can gain the skills they need for long term, is a positive outcome. And I think that's where we've got to be heading. And this bill's not heading towards that. It's heading away from actually taking any responsibility at all. As I said before, Cheshire, who have the targeting program for what they do, various states across the US run programs. Their whole desire is to keep young people out of the prison system through the US. And whilst here we hear much about crime in the US and we hear a lot of negative, there's also some really positive stories about them closing prisons, about ways they're dealing with young people when it comes to mental health, drug use, where they actually focus on the issue. They focus on the cause that's creating the crime. And if you look at the Sober 24/7 sobriety program in Florida, it's solely designed on if a person commits crimes when they're drunk, then we need to work out how to not get them drunk. If a person commits crime because they're stoned on drugs, we've got to put programs in place to stop them getting stoned and on drugs. So I think if we're going to be looking at a justice reform through our state, the justice reform can't be saying you're not going to be held responsible for anything. It has to start saying you will be held responsible, and part of that responsibility and the outcome is we're going to put you on these programs where you are going to either, via yourself, support yourself to get better, or, if required, the government or other organisations can step in and offer you that assistance. Because if they come out of those programs better and committing less crime, we kind of all win. We don't need to worry about making the changes and not making them responsible. We need to actually say you are responsible for your actions and we're going to put things in place to protect you. Another stage of this was the police powers, and it's been raised with us, some of the concerns around the police powers, and it's actually very interesting. I don't think anyone actually supports these powers, the police powers. There's a group that say they're too far and a group that say they're not far enough. I haven't had one person that says, well done, congratulations on these. Now, in saying this, saying there is an increase in the raising the age, I get that. Taking that out of it, I think there has to be powers in place to move young people. So we are supportive of the fact we have to have those powers. The concerns raised from this with Victoria Police Association is the amount of hours that it's going to take for each time a young person is moved or relocated in paperwork. It's actually more paperwork under this system than it was to charge a child. So it's going to take police resources off the street. There's got to be protections put in place to ensure that the limitations on the Victoria Police, they understand what they are. There's search powers that will be gone, so if a young person goes in and steals items from a shop, there's no more search powers to search for the stolen items. If you're going to put a young person in the van to move them for their safety or for safety of others, you don't have a search power anymore to search them for a knife, because they've changed it from you could do a safety search to now the search is only on reasonable belief, and by definition of reasonable belief, you have to have basically enough evidence to say the person has most likely got a knife on them. Well, you can't do that when you just find a kid in the middle of the street. You can't just guess it. And so you're putting police at risk of being sued for searching them for safety, for their own safety and for the safety of the young person. So you need to actually readdress that in this, my view, to rewrite this bill, to ensure police have that protection, because we're going to be asking them to move them. And the other part of this is there's already laws in place for people under 10 and how they're dealt with by Victoria Police. Now we're going to have under 10 and then a 10 to 12 and then a 12 and onwards. We're going to have 3 different elements for police to guess which element they're going to use for moving a person on to make sure they're protected. And it's a lot to do. In conclusion, and I look forward to hearing the member for Malvern and the positions that he's going to put up as well, but we've got to make no mistake, this bill is not about youth and crime. It's a function to divert people away from the justice system, but what we're saying is we need to make sure we hold people accountable. The Victorian opposition, when they go through this, we can't reasonably support this bill in its current state. We'll be opposing the bill when it goes to a vote. We'd ask for support for the reasoned amendment and have a focus back on how do we ensure people are responsible for their actions and that the outcomes are a government or organisations are supporting them to not commit crime in the future.